take no more than 13 minutes, according to admissions by both counsel. It's case number 118210 in the matter of Daniel Hart Phillips, respondent.
Thank you. Penny Moylan, appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I would like to request 2 minutes for rebuttal if necessary.
2 minutes is granted.
Thank you. As this court is aware, this is an original proceeding in discipline. The complaint in this case was filed by a prospective client named Alicia, and I'm going to use her first name because as will become more apparent later, I think it's relevant. Alicia had no former relationship or contact with the respondent, Mr. Phillips. In this particular matter, she had called him to get his assistance in a domestic matter. While she is speaking to him on the phone, Mr. Phillips referred to her as baby, and that caused some concern for Alicia, and so she started tape recording the conversation. We have the tape recording in the record. We also have a transcript of the recording, and it's really probably only about a minute or two of what she recorded. And at the very end of the recording, while Mr. Phillips is telling her where his office is and what documents to bring, he ends the conversation with this statement, and don't wear any underpanties. Alicia hung up the phone and then proceeded to file a complaint with our office. She also filed a police report. I do not believe anything ever came of that police report, but Mr. Phillips can speak to that if necessary. In his initial response to the complaint that was docketed, Mr. Phillips admitted to the conduct. And he said, and this is in his exhibit, volume 3, pages 8 through 10, "There is absolutely nothing said to me on her behalf that would have warranted the outlandish, crude, and totally unacceptable remarks I made toward her, without warning and totally without provocation on her part." In that initial response to the complaint, Mr. Phillips also went on to explain that earlier that day he had been at the courthouse and he had ran into a former client. And that former client was wanting his services in a new matter, and she basically made the proposition that she didn't have any money, but that she would trade sex for his services. Mr. Phillips said that he told her that that was completely unacceptable, and basically got in his car, was driving back to his office, and it started triggering all these emotions that he had had in dealing with a former wife who was a drug addict and would trade sex for drugs. And he said when he got back to the office, he called Alicia, and unfortunately, his comment was basically the fallout of having not dealt, with the previous issues with his wife. In his initial response, he also told our office that he immediately got into counseling. We went ahead, the review committee found probable cause, a formal complaint was filed. He admitted to all the facts in the formal complaint. Prior to the hearing, Mr. Phillips submitted a proposed probation plan. And part of the probation plan was he said he would continue in counseling. He would have his secretary sit in with all meetings that he had with female clients, and all phone conversations with female clients would be conducted on the speakerphone in the presence of his secretary. He also listed a letter of apology. We had a hearing on May 31st, 2017. At this point in time, like I said, the facts were stipulated to, but the rule violations had not been stipulated to, although later in the hearing, Mr. Phillips did stipulate to an 8.4G violation. So really what we're going to talk about at the hearing was aggravation and mitigation. And Mr. Phillips' counselor testified, and she actually did a great job of explaining why this comment was sort of a comment that was made in anger. She was cross-examined about any sort of other deviances, such as sexual addiction. She diagnosed him with an adjustment disorder. She said that he hadn't dealt with his previous wife, the issue going on there, and then currently his current wife was wanting to divorce him, and he had all this stuff going on. And basically, he just made this unfortunate comment, and that she thought his prognosis was good and that he would not repeat the behavior. Mr. Phillips then testified after the counselor, and here's where the case sort of took a turn in a direction that I had not seen coming prior to the hearing. At that point in time, Mr. Phillips testified that he had ran into this former client, and her name was Lakeisha, at the courthouse that day. And he again reiterated what he had said in his initial complaint. However, he now said for the first time that when he went back to the office and had this phone message to return a call to Alicia, that when he was talking to Alicia, he still thought it was Lakeisha that he had seen earlier at the courthouse. I was surprised by this testimony, and upon cross-examination, I said, well, weren't you really just following up on this offer that had been allegedly made by Lakeisha earlier? And he stated several times that no, it was something that was done in anger, and it was sarcastic, and it was still the fallout from these problems that we had talked about earlier. I, at that point in time, asked the hearing panel to go ahead and listen to the recording so they could make their own determination. At the end of the hearing, that I argued that his misconduct, the statements to Alicia, constituted violations of 8.4D, conduct prejudicial to the administration of justice, and 8.4G, conduct that adversely reflected on his fitness to practice law. I also argued that this misconduct would warrant 1 year suspension from the law. However, here I did a bifurcated recommendation. I said, if you really believe that the comment was just made in anger and it wasn't a follow-up, then I recommend you place him on probation if he submits an amended probation plan where he has an attorney that will be his probation monitor. If you believe that he was following up on the offer from Lakeisha, then 1 year suspension still, serve 90 days of it, amended probation plan. The respondent admitted to the 8.4G, asked for published censure to be placed on probation. He did submit an amended probation plan after the hearing panel where he had a probation monitor. The hearing panel issued its report on September 5th. They found a violation of 8.4G, but not 8.4D. They found the following aggravating factors: 2 prior disciplinary offenses, and then this is important, submission of false evidence during the disciplinary process. Basically, they did not believe Mr. Phillips' testimony that he was talking to Lakeisha when he was talking to Alicia. They listened to the tape. He was not sarcastic or angry. They didn't make any finding as to whether he's following up on the offer or not. They just basically said that deception during the disciplinary process was an aggravating factor. Substantial practice in the law was an aggravating factor, vulnerability of the victim. Mitigating factors, they placed some great weight on his personal and emotional problems, that he admitted to the facts in the complaint, his previous good character, his remorse, and the remoteness of his prior offenses. Ultimately, the hearing panel recommended the 1 year suspension, but based upon not only his conduct of the statement to Alicia, but also his deception in the hearing, that he serve 30 days of it and then be placed on probation with the following conditions. Roger Falk serve as his practice supervisor, that they meet monthly, allow access to client files, etc. Office assistant, sit in on all the meetings, I've already talked about that. That he continue in the psychological treatment, and that he attend lawyer groups at the WBA. Just to wrap it up real quick, Mr. Phillips submitted his affidavit, I think last week, and in that Roger Falk and his secretary submitted the affidavits, and it appears that Mr. Phillips has not been complying with those proposed probation terms. To date, he has not attended the lawyers groups at the WBA. He has not had regular monthly meetings with his practice supervisor. They met in June, but they did not meet in August, September, October. They did meet on November 29, 2017. His secretary is sitting in on all the client meetings and listening to the phone conversations. At this time, pursuant to Supreme Court Rule 211G5, a respondent is supposed to submit an affidavit showing they're complying with the probation terms. Because he has not established that, I stand on my recommendation of 1 year suspension. However, I do not recommend at this time that he be placed on probation since he has not established that he's following these terms. And I also would request, because there is no probation that he's been complying with, I would just request a reinstatement hearing that can properly address the issues, so he can show that he has properly addressed the issues that caused the underlying misconduct, as well as his deceptive conduct during the hearing.
Okay, so I got confused at the last couple sentences. You want a 1 year suspension with a reinstatement hearing?
Correct.
Okay.
No probation in the intervening time?
No.
Any more questions? Thank you, counsel.
May it please the court, Craig Robinson, appearing on behalf of the respondent, Daniel Phillips. On April 27, 2015, Dan had a phone conversation with a prospective client and spoke suggestively to the woman. A complaint was made implicating Rule 8.4G, which the rule states it's professional misconduct for a lawyer to engage in conduct that adversely reflects on the lawyer's fitness to practice law. A trial was held before the panel. There was no exceptions taken by Dan to this finding of 8.4G, and we find ourselves here today discussing the appropriate sanction. in support of the sanction that was recommended by the panel. I want to just point out just a few things and then give Dan an opportunity to talk about the things that I know are important in the limited time that we have. First of all, he cooperated with the investigation and all the pending matters. The date of the complaint was early May of 2016. The complaint was filed by the board in February. There was a counsel response. We had our trial on May 31st. We never took any issue with any of the facts. He was extremely remorseful. The record clearly shows the level of remorse and the explanation for Dan's conduct. He submitted a letter of apology to AJ, and he had letters of support vouching for his character and professional reputation, all of which were submitted as part of the record. As I've said, we've taken no exception to the recommended sanction, which basically we are agreeing that a 30-day suspension is appropriate under the circumstances. You're not hearing me saying, hey, let's go back and try to get something less. It was a conscious decision that Dan made after counseling with me, and it is part of his, I guess I'll say, personality, that when he makes a mistake, he agrees he should be punished, and this is his punishment. We have supported his probation by a Rule 212 submission, the best that we could put that together. I think he's been largely compliant, and I just want to talk about one small objection I have to Ms. Moylan's contention that he's not been compliant. There was a lot of things inside that probation plan, and one of them that has caught the eye of Ms. Moylan that she's concerned about was that he was going to go to a lawyers' meeting, which is a loose group of lawyers that have some issues in our community, and they meet on Wednesday. Well, Dan was going through his divorce from his wife, and it was just finalized. And he had responsibilities to his 2 young children on Wednesday. And he could not meet on Wednesday with the group. And so he couldn't fulfill that, and he didn't know how to get around that. So instead of getting all worked up about it, he went to other additional AA meetings and supplemented that Wednesday meeting with additional AA meetings. And he can talk to you about that. The bottom line, we believe that he is being entirely compliant. It's been a difficult few months for Dan because of not so much because of this. This happened in 15 or 16, or 15 and 16, but because of the pending divorce and the things that go with that, and the finality of that, it was a sad time for Dan. So I believe the offending conduct that adversely reflects on Dan's fitness to practice law is arrested, and that the public will be benefited and protected by Dan's continual addressing of the matter through the probation plan, which did include continual counseling. And there's one other little legal point I want to make about the contention that he was being deceptive in the panel. From a legal standpoint, I think you have to consider his uncontroverted testimony as a whole. No one got up there and said, well, he's lying. And I think his testimony is entitled to the same test of credibility as any other witness. There were no other witnesses, number one. So from a legal standpoint, I think his testimony of what happened and why it happened stands uncontroverted. Second legal point.
Well, there was other evidence.
Well, there was other evidence, but no direct evidence that says, well, you're a liar. No one.
You're not suggesting the panel couldn't consider the respondent's testimony alongside the recording of the conversation he was testifying about.
My next point, if I can respond to that this way.
Excuse me, counsel. We're now 4 minutes after 12. We have a noon commitment for the court. So here's what we need to do. Between you and your client, I'm going to give you 2 minutes to wrap up, okay. Or we'll come back at 1 o'clock and resume where you are right now.
No.
I just want to give you a choice because we have commitments.
I have a commitment at 1 o'clock at the Department of Revenue myself, so
All right.
I'm gonna wrap it up. I just wanna make one quick point and let Dan talk.
Okay.
The context, not all of the telephone conversation is in the record. In other words, the first half of it. So from a legal standpoint, we don't know what the full context of that conversation was. With that, Chief Justice, I'll let Mr. Phillips address the court.
Thank you.
I appreciate this court allowing me the opportunity to address it. I just hope that this court considers my case as important as any other case that has been heard this morning, because I know now there's very little time. Let me say this. I have been back practicing law now for 12 years. And I came back knowing that my suspension was only 2 years, and I took 4 years to come back because I wanted to have the right attitude when I came back. I have practiced almost without incident for 12 years, and I've enjoyed the practice of law. I wanted to come back because I enjoy touching people's lives in small ways. On this particular day, I didn't. I have a tendency not to charge people for their initial interview with me because I want to be able to give them advice and let them know what they need to do. I met a woman at the courthouse who set in motion my emotional day that day. My wife, this incident happened at the end of April. My wife signed her divorce papers in May. I was walking on pins and needles in a divorce situation with 2 young boys. I came back to my office in a fog, and my remarks were totally crude and out of line. They had to do more with what happened earlier in the morning and with what I was going through in my divorce than anything else. Had I focused on the individual at the courthouse, the first individual I ran into, had I focused on her needs rather than her solution, I might have resolved part of this. And if in my conversation with Alicia I had done the same, I probably wouldn't be here today. My remark is truly an anomaly in how I approach my clients. And I take ownership of that remark. When the investigator from the disciplinary's office contacted me, and we spoke over the phone, I took ownership of that remark then. Every day I have to deal with this. And now I'm involved in a national atmosphere that deals with sexual harassment. And I've been going to counseling for well over a year and a half. I went to counseling to address this particular issue. It involves sensitivity. And when I see a new situation on the television, I don't turn it off. I face it. And I recognize that whether out of anger or some other motivation, I was part of that. I want to learn from that experience. And I don't care how old I am. May I address one other thing? I wasn't going to those attorneys' meetings because I have this commitment with my boys who are almost 10 and almost 8. I could not compromise that and be in a full custody hearing. And I must say it was a tremendous hearing. The other side submitted a bill of $22,000 in attorney's fees that they wanted me to pay. These last several months have been tremendous in terms of the pressure. But I have to say this, through counseling, I've been able to make that adjustment. And of course, my boys are my number one concern in my life. I cannot apologize enough for the remark that I made that day. And I carry that around with me. But I truly believe that in and of itself, it's an anomaly in how I treat people and how I act. I consider it a real privilege to come back and practice law. And I practice law because I think it's important to touch people's lives in a small way. When I couldn't go to those attorney meetings with those gentlemen, I worked out an arrangement now in this divorce settlement where now I can make that on the second Wednesday. And in the meantime, I was doubling up on Al-Anon meetings, which I truly believe are tremendously more beneficial. I attend one that is an all-men's group. I attend another that is an all-women's group. And I want that because I want to be able to feel the sensitivity of both sides.
Counsel, what is it you want us to do with your case? in terms of discipline?
Your Honor, Chief Justice, I believe there should be some suspension period. But I know that when that ball begins to roll, it will impact the people that I represent now. And yes, it will impact my sons and to some degree the future that I'm trying to put in balance. But aside from that, what I really want you to understand is that Alicia, and I want to call her by her first name, she got caught in the crossfire of my anger that day. And my life was falling apart. As I had memories that came back and haunted me from my first marriage. I was now looking at my current marriage. I can't entirely answer that question, and I think that I have to the degree you want me to as it relates to me. But I want you to know that the biggest reason I'm here is because of what the remark that I made to that individual on that day, who was a complete stranger to me. That's something that's extremely intimate to me, and I want you folks to know that. Thank you.
Thank
Can
you.
you address your sporadic meetings with Mr. Falk?
Yes, I can. We had a significant meeting early on, and as soon as the divorce, we had another. But we have gone to lunch together at length and discussed it. We have met with each other at the courthouse. He's given me a number of ideas. And I assure you, my secretary had issues about coming up and hearing. My secretary had issues about coming and appearing before that hearing panel. She had an issue because she was upset because I made that remark. I've had her as my secretary for 20 years, and she clearly considers that out of character for me. She listens in on all phone conversations, and she is present during all meetings. I just wanted you to know that that has created a situation in my office that is extremely sensitive. She supports me, but she's at the same time upset with me, and I understand that.
Thank you, counsel.
Thank you.
You reserved some time for rebuttal, 2 minutes. Could you step here so people can see from home?
I will waive rebuttal unless the court has any
Well,
questions.
is his explanation of the sporadic meetings with Mr. Falk accurate?
I would just address you to look at Mr. Falk's affidavit. I would not characterize their courthouse,
Right.
and
just
there's
running-
nothing about a lunch in there either. They have not had the meetings that are anticipated by the probation plan. The last one I believe was it was November 29th, but prior to that I believe was July.
Thank you.
Any other questions? All right, thank you, counsel.
Thank you.
We thank all of you for your arguments this morning and this afternoon. The court will take this matter under advisement. That concludes